I went down to talk to the local sheriff right here in Gaston County, down here in North Carolina. I went in and had a conversation with him. And I showed him this ruling that I got from the administrative court stating that the local police department were purely private contractors, non-public officials. And I walked in there with my PAG paperwork that I got from Congress, validating that I hold position as a private attorney general, and I walked in with the legislative enactments from 1866 all the way up to 1996, showing that this was a 100% legitimate position granted to the people by Congress, that we had that authority to walk in here. So I walked in, talked to the sheriff, and I started laying this stuff out. And I brought up about the manufacturer statement of origin, the MSO of your vehicle. And I asked him, I said, let me ask you a stupid question here. Seeing as how we went after the Department of Transportation and the police department on a driver's license issue and a tag issue, who owns these automobiles out here on the road? He says, the state does. I says, and they own it through the MSO. Is that correct? He says, that's absolutely correct. Because they hold the MSO, they own the vehicle. I says, good. I'm glad we get this straightened out. I says, now, who owns your cruisers for the county? He says, well, the county owns them. I says, okay. I said, but you guys have to put your own gas in it out of your own pocket, right? He says, no. I said, you guys have to buy your own insurance? He says, no. I said, you guys got to do your own maintenance, right? He says, no, we got the city that does all this for us, the county. They put our gas in, we got a credit card. They pay for the gas, they pay for the insurance, they do all the maintenance, they do all the upkeep for the vehicle. My deputies don't pay a thing for these vehicles because the county takes care of all of it. I says, okay, now let me ask you a stupid question. If you and I can agree that the state owns all these automobiles out here on the road, including mine, I said, who's supposed to put gas in my automobile? He says, the state. I said, who's supposed to pay insurance on it? He says, the state. I said, who is supposed to sit down and do the maintenance for it? He says, the state. I said, that's exactly right. I said, now let me ask you a question here. He says, what? I said, you guys don't get a paycheck, do you? He says, well, we get paid every 2 weeks. He said, well, that's funny. I said, I don't get a damn paycheck off anybody. He went, oh, shit. I said, yeah. You know as well as I do. I don't have to make car payments, and I don't have to pay insurance, and the state's supposed to pick all this shit up. He says, Mr. Class, there's going to be a standing order to my deputies not to stop you. If you have any problems with any of my deputies, here's my phone number, and here is the chief phone number. You give either one of us a call if you have any problems with either one of our deputies. You call us before you do anything. I says, why? He says, because you have stripped us of our immunity, and now you can sue us in our private capacity. I said, that's exactly what I did, and that's why I'm in here talking to you right now, to give you a heads up. So we got that done with the county here with the police department. Well, then I had a problem with the Lincoln County because I was running a blue light in my Jeep. I didn't have it plugged in. I just had it sitting in there. And I was pushing the envelope on this. I had 12 sheriff cruisers from Lincoln County swarm my vehicle. Now, they didn't have no blue lights on. There was no flashing lights. They just swarmed my vehicle, and they brought the state insurance inspector with them. And here in North Carolina, the state insurance inspector is the one who gives the license to the bail bondsmen and to the bounty hunters. Well, because I have bounty hunter and PAG all over my Jeep and all over my excursion, they was going to get me for impersonation of a bounty hunter. So they brought the insurance agent in. The insurance agent and I sit down, and we got into our conversation. He said, well, Mr. Klaus, he says, you're not registered with the state of North Carolina to be a bail bondsman. I said, you're right, I'm not. I said, did you read my Jeep? It says 14th Amendment, Section 4, bounty hunter, public debt collector. I said, do you understand what this means? He says, oh my God. He says, you're a constitutional bounty hunter. I said, that's exactly what I am. He looked at the sheriff department and says, you can't touch this man. He is a constitutional bounty hunter, and you can't lay hands on him. He said, but Mr. Class, you can't have that blue light. I said, yes, I can. He says, you're not law enforcement. I said, oh, I most certainly am. If I'm a bounty hunter on the federal side, my obligation is to arrest you people for misconduct, and I already got one ruling that you're not police officers. You're nothing more than private contractors. Well, they hauled me into court, got before the judge. Prosecution said, Your Honor, Mr. Class had a blue light, and according to North Carolina statutes, that blue light had to be manufacturer original equipment. I said, I object. I said, you want to repeat that? She said, it had to be original manufacturer, original equipment. I said, I object. I said, I can sit here and show you right now on your police cruisers. Your police cruiser didn't come from the dealership from Detroit where the manufacturer was. It didn't come with blue lights. It didn't come with the pinstripes on it. And your deputy and your symbols on the side. I said, you have a private contractor out of Charlotte that you take your cruisers down to, and they put lights on it, and they put your markings on it, and they put your sirens on it, and they put the roll pin in this thing, and the judge says, we're going to overrule that section of the law. He says, Mr. Class, you're not North Carolina law enforcement. You may be federal, but you're not state. And therefore, you can't have the blue light. The point that I hit him up on is when she tried to use original manufacturer equipment, I was able to come back in and show them not one of these cruisers come from the dealership, and the judge says, we're going to skip that part of the law. This is the significance of understanding their rules and their regulations so you can show their errors in this. Well, I got involved in another case helping someone else, and we went after the sheriff department. And we got the ruling again from the administrative court that the sheriff department and the court system and the prosecutor's office and the attorney general's office at that time and the county jail were not state or county offices. They were independent contractors. They don't work for the state. So I got a second ruling on that. I did the same thing with the State Highway Patrol. I got into it, did the same thing. I got a ruling. They don't work for the state. They are purely independent contractors. That's the same thing with the governor's office. The governor's office is not an agency of the state. And I came back and said, excuse me, what do you mean the governor's office is not an agency of a state? It is an elected position. And the administrative court upheld the governor's office is not part of the state whatsoever. So I got these type of rulings by going after them. So what happened here by me doing this? I went into D.C. And of course I had my bounty hunter and my PAG stickers all over my Jeep. I had my vest on. I went into the House of Representatives down to the Judiciary Committee to file more paperwork because I was involved in another federal court case. I had to file paperwork in. I walked over to the Senate, to the Judiciary Committee, filed paperwork in. I come walking out. I come down walking to my Jeep, and my Jeep was taped off. I had about 6 cruisers and more than a dozen police officers down there, and one come up and says, is this your Jeep? I says, yes. He said, turned me around, he handcuffed me, took my keys off of me. They sit down and ask me, says, Mr. Class, do you have any firearms in your Jeep? I says, no. I said, the problem is you don't know what a firearm is. He said, what do you mean? I said, you don't know what the legal definition of a fire alarm is. And they said, well, anything that shoots out a projectile. I says, no. I said, did you bother reading the 1934 National Firearms Act? or the 1968 Gun Control Act, or the Firearms Owner Protection Act of 1996. Did you read Title 26 under the IRS Code 5845, or under Title 27 CFR under 479.11 under ATF that a firearm is, by legal definition, a shotgun that's been modified to a barrel of less than 18 inches, overall length less than 26, a rifle that's been modified to a barrel of 16 inches, overall length less than 26, a fully automatic machine gun, and a silencer. You're not going to find any of them in my Jeep. What you will find is a pistol and a rifle and my carry concealed permit that I got from North Carolina that allows me to carry. And besides, I hold position. I just went through Congress again. I got documentation stamped by the Judiciary Committee of the House and Senate to validate again my bounty hunter and my PAG position as legislative authority over yours. Well, this didn't go too well. So for about an hour, I was being interrogated. I had a couple of cops come up to me, want to know how I was doing, want to know where my buddy Carl was at, Carl Weston. I said, well, he's at home. He said, well, you helped us to save our home because you helped us file paperwork in, and we got our homes, and they dropped the mortgages on us. So we got talking here a little bit for about an hour, and they took me back to the barracks. Well, they took out my hearing aids. They took my hearing device for me to be able to hear. And they took my shoestrings. They basically stripped me down just to pants and shirt. They had me handcuffed to the wall. I was in there for approximately 3 more hours. I had FBI. I had U.S. Marshals. I had all kinds of federal agencies in there. While I was there, they were talking to me, and the one FBI agent made the comment. He says, "You're one of them sovereign citizens, aren't you?" I said, "I resent that." I said, "That's profiling me." I said, "By the way," said, "you don't even know what the term means." I said, "Because if you would check North Carolina's Constitution, it says sovereignty lies with the people, and that the government is derived by the people's rights to create a government. So that does make me a sovereign. Because your system was derived from me, the people." I said, "On the other hand, I've got Supreme Court rulings that says you guys are the sovereigns. So which one of us is the terrorist? The one who's trying to enforce the laws, or the ones who's violating the constitutional protected rights and who don't know the law? So which one of us is the terrorist here?" So they got off it, and they sit down and said, the FBI says, "But Mr. Klaus, you don't believe in paying taxes, do you?" I says, "No, I don't." "Why don't you feel you have to pay taxes?" I said, "Okay, let me answer this question." I said, "First off, get me out of this handcuff, get me my computer, and get me my hard drive. I will walk you through the congressional records, and I'll show you why I don't have to pay taxes." So, "Well, we're not going to do that." I said, "Well, fine." I said, "Then has anybody got a Federal Reserve note in their pocket?" They looked at me. I said, "Oh, come on now. Somebody has to have a Federal Reserve note." "We don't know what you're talking about." I said, "Oh, I'm sorry. That's right. You guys get paid gold and silver, don't you?" They looked at me and said, "What do you mean we get paid in gold and silver?" I said, "Well, if you don't get Federal Reserve notes, then you guys get paid in gold and silver." I said, "Well, we don't get paid in gold and silver." I said, "Has anybody got a little green sheet of paper that's got a 1 or 5 or 10 or 20 or 50 on it?" And the FBI agent pulled out a $5 bill. I said, "Good." I said, "What does this say across the top of this $5 bill?" He says, "Federal Reserve note." I said, "Oh my God." I said, "Yeah, Federal Reserve note." I said, "Do you know what a Federal Reserve note is?" I said, "Do you realize that Congressman McFadden in 1933 and 1932 on the floor of Congress stated that the Federal Reserve note is not money, but a mere promise to pay you someday? and that Federal Reserve note under the Federal Reserve Act of 1913, Section 16, says this is a Federal Reserve stays with the Board of Governors and the Federal Reserve banking system, and is only issued to a Federal Reserve agent only, and it is the obligation of the United States. I said, could you sit here and tell me how I'm supposed to pay taxes on something that is a promise that is only internal currency? They looked at me and they got off the topic. Well, we started explaining. I started giving a mini seminar to these guys. Well, the 3 hours that I was doing it, roughly every hour, they had to switch. A different group come in because I was overloading them with so much knowledge, and I was backing it up. I was telling them where it was sitting at in the congressional records. I was telling them where it was at in the statutes at large. I was explaining it to them, and I think what they were doing is going out there in my computer and they was checking it and validating it. But after about 4 hours with these idiots, the U.S. Marshals finally told the D.C. police, he says, Mr. Class is not a threat. We're not going to do any charges against him. And that's what the FBI told me. He said, he's not a threat. Well, D.C. wanted to push the issue. Well, then that's when they decided to Mirandize me. They sit down and ask me, I have the right to remain silent. Anything I say can and will be used against you in a court of law. If I can't afford an attorney, one will be appointed to me. They said, do you understand this? I said, yeah. Well, I signed that little sheet of paper. Well, after I signed that sheet of paper, I asked them a simple question. I said, now, you guys have finally Mirandized me after 4 hours. Does that mean that all the evidence that you took out of my Jeep and all this questioning that we've done here for the last several hours, that means you can't use any of this, right? And the 2 FBI agents and the 2 U.S. Marshals said, oh, shit. I said, yeah. I said, you guys got into my wallet, did you not? Says, yeah. Did I not have a Miranda card in my wallet? And you didn't see this? And you're going to question me for roughly 4 hours and then Mirandize me after the fact? I said, you can't use any of this information. Well, they put me in jail for the weekend. They handed me a public defender that came up to me, and I was supposed to talk to at the window. Him and I had to go around. But he said, Mr. Class, he says, my job is to get you out of here. He said, and that's what my job is get you out. Just shut up and let me get you out. So we sit down, we talked, we went up before Judge Sullivan. The prosecutor cross-examined the police officer, and when it come time for Dworsky to sit down, Dworsky told the judge, says, Your Honor, Mr. Class here holds position as a private attorney general and a constitutional bounty hunter through Congress. I've already validated this. Judge Sullivan looked at me. He says, Mr. Class, we're going to dismiss your case. You get your Jeep, you get your stuff, and you get out of D.C. You're no longer allowed in D.C. You're barred from ever coming back here. So you get your stuff and you get out of here. I said, okay, fine. So I went down to the police department. I got walking down the street, and I didn't know for sure where it was at. And I come up to one of the police officers. And I showed him who I was. He says, you're the one. I said, what do you mean I'm the one? He says, you're the one that has got this place terrified. He says, these people are absolutely scared of you. I said, what the hell did you do to these people? I said, you want to know what I did? He says, yeah. I says, I went down to your law library. The Library of Congress? He says, yeah. I said, I learned how to read your books. And he looked at me. I says, yeah. It wasn't the gun I had. It was the knowledge that I possess. It is the understanding that I have. I said, and this is what terrified them. Because I knew too much. That's what the attorney sat down and told me. He said, Roger, you know too much. Well, when I went down to the police department to get my stuff, well, the prosecutor decided to re-indict me and bring me up before a grand jury, bring me in for another hearing. So I got the case dismissed once, but they decided to run me back through the ringer again. Well, getting ready to go home, I had to come back up. I wasn't allowed to have my Jeep. I wasn't allowed to have any of my stuff. But when I came back up, they returned my Jeep to me and my computer, and at that time, they brought me before a grand jury. Well, you're not allowed to go before a grand jury. They don't allow you before a grand jury, and I insisted on it. I said, I am going before your grand jury. I have a right to talk to your grand jury. So when we got in there to the grand jury, I proceeded to explain what I ran into. I said, you have up here a definition problem. I said, I was charged for a firearm, and I did not have a firearm. I had a rifle, and I had a pistol. And if you're going to charge me, you have to charge me under the true legislative name of these stuff. I said, not only that, your Heller case versus D.C. and your Parker versus D.C. case up here made your gun laws unconstitutional, as well as McDonald versus Chicago. Well, the grand jury sitting there said, well, what that means is we can only have it inside the house. I says, no, you've been lied to. You're allowed to have them. And they said, well, Mr. Class, your permit is not valid here in North Carolina, up here in D.C. I said, yes, it is. I said, my permit comes under Article 4, Section 1 and 2 of the Constitution. Full faith and credit from one state to the next. Also comes under the 14th Amendment, Section 1, equal protection under the law, as well as Title 42, 1981, equal protection under the law. I said, so you have to allow my permit to be up here. I said, well, the problem is D.C. is not a state. I said, yes, you are. I said, I can walk you through the laws and show you where it is declared to be a state. You may want to play both sides of the fence, but the bottom line is the laws come from here, and you spread it out to us in our states. And if you're going to spread your stuff out here to us, you're going to have to allow my permit because you accept my driver's license. Well, the prosecutor sat here and told the jury, so you only have one decision to make. Did Mr. Class come into D.C. with this firearm, rifle, pistol? Did he come into D.C. with? That's the only decision you have to make. Did he do this? And of course, that was a slam dunk. Yes, they found me guilty. Well, then I started going into the federal court because they transferred me from the Superior Court over to the federal court. I got in front of Judge Wilkins. And Judge Wilkins sat here and swore me and says, Mr. Class, raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God. I says, yeah. He says, now, if you commit perjury, if you lie under a sworn oath, then you can be charged for contempt of court. I says, now, wait a minute. I said, let's you and I have a talk here. Are you telling me that anybody who takes an oath, if they lie, that's perjury and contempt? I said, even on your side of the fence? He says, it most certainly is. I says, good. Let's talk about what your prosecutor did. Did he not take an oath to the Bar Association that he would not mislead, misconstrue, put false information before this court? Did he not swear that he would uphold the Second Amendment? The judge says, well, we're going to postpone this hearing. I said, we're going to postpone it. Well, then we got up in front of Judge Kessler. And my public defender sit down and talk, but they was pleading me guilty throughout the whole thing. And I got a chance, I interrupt. I said, hey, I ain't going to represent myself because I've already filed a bunch of paperwork in. I filed a bunch of paperwork in for an in-camera hearing to where this was put on the private side. I went back and filed in everything that they were doing wrong. So when I got a chance to talk to Judge Kessler said, well, Mr. Class, you really don't want to represent yourself in here because you have to know the rules. You got to know the criminal rules procedure, and you have to know the rules of evidence. You got to know the local rules. And, we as attorneys don't know all this stuff, but, for you not being educated in the law, it's really going to be harder for you. I said, that's all right. I'll handle it. So she postponed, got another status hearing. I walked in. I filed paperwork in under Rule 12 that I have a right to file paperwork, and I filed my own enter of appearance into this thing. Well, when I filed my enter of appearance in, I made the separation of the all capital name. I showed all capital United States of America versus Rodney Class, ward of the state, a state name. He is the trust for the state. Then I come down and put my Rodney Dale Class in proper English as third-party intervener, private American national, private attorney general. So I made a separation between the all capital name and the living name on this. And I filed my paperwork. I filed my enter of appearance into this thing. Well, they accepted my enter of appearance. So that allowed me to come in and start filing paperwork in. Because I got rid of my public defender, even though they had him on the sideline. So when we got in there, and Judge Kessler proceeded to talk to me about, well, Mr. Class, do you have your paperwork? I says, no. I said, I'll file paperwork into the clerk of court. I have not got nothing back. They're sitting on my paperwork. She said, well, you're supposed to be electronically filing this thing in. I said, I can't file this electronically in. That's only for attorneys. I'm not an attorney. I'm a private attorney general, but I'm not an attorney. I said, I can't file it in. I said, I have to send mine in with registered mail with a envelope, pre-stamped, pre-addressed. All your clerk of court has to do is go stamp, stick it in the envelope, throw it in the outgoing mail for me to get it back. I said, I ain't got squat back off your people. I said, I am here to talk about the rules. I had 2 little books that came from the Judiciary Committee, from the House and Senate. The Rules of Evidence and Criminal Rules Procedure. They're a very small, thin book. Then I ordered online a heavier book that dealt with a whole lot more information. It was an annotated version. I looked at Judge Kessler and I sat down and said, now, which one of these books do you want to talk about? You want to talk about these little cheap, flimsy ones, or do you want to talk about the annotated one, which has all the case law and the history and the foundation of all these rules? Which one would you like to talk about today? She looked at me and she says, we'll go with those little ones. I said, fine. I said, but I want this big book put in here as evidence into the record to show that you're not following the rules. I said, now, let's sit here and start out. Let's start out with Title 28, which is Judicial Procedure, under Title 2255. 2255, which is habeas corpus. I said, you do understand if I prove constitutional violations or statutory violation, you have to dismiss my case? You do understand that, right? Because your rules sit here and say, under the rules of evidence, under 402, that the Constitution is admissible evidence already put into the record, and the statutes are already admissible evidence, and these rules are already admissible evidence, and Supreme Court decisions are admissible. That's the same thing with 501, and under 802 and 902, it talks about prima facie. I said, but let's go back to 2255. Let's talk about the constitutional violation. I said, first off, let me ask you a stupid question. I said, who is the corpus delicti in this case? Who's the injured party? And she was stammering around and stuttering with the word corpus delicti, and she was sitting here asking the prosecutor, do you understand what he's asking here, corpus delicti? I said, quit this. I said, you guys were first-year law students. You were taught who is the injured party. And she would say, well, Mr. Class, you violated the statutes. That's the corpus delicti, the statutes. I said, do you really want to tell me that? And she says, well, yes, you violated the statutes. I said, good. Now, let's get into the habeas corpus side. So I proceeded to explain Article 4, Section 1 and 2, full faith and credit. The 14th Amendment, Section 1, equal protection under the law. Title 42, 1981, full faith and credit and equal protection under law. What one state gives, you have to give me in this state. I said, now, as you sit here and said, Mr. Class, you broke the statute. You violated the law. Let me walk you in and show you where your prosecutor, as he is a bar agent. He is a federal bar agent under Title 36, United States Code, Chapter 705, Section 70503, that sits here and says if he does not uphold the Constitution, he does not uphold the statute, he has disqualified himself. He is now disbarred. I said, you do realize that he has violated the Constitution and the statutory law under Title 36? He has now disqualified himself. He has violated the law. He has advocated the overthrow of the Constitution, which is a violation of the Smith Act of 1940, which is an act of treason. And you do understand that he's violated Title 18, Chapter 175, 2385, which is insurrection, sedition, rebellion, and treason. I said, why is this man still sitting in this courtroom? Why is he not being charged for treason? And I started to go through this stuff for about 35 minutes with her. As she looked over at that prosecutor, she said, can you rebut this man? He dropped his head. He shook his head. No, he could not rebut one single thing I said. I said, on top of it, he didn't even Mirandize me to after 4 hours of interrogation. And she said, did you Mirandize this man? And he shook his head, and she screamed recess, and she ran out of the courtroom. The entire time that we're going into these courtrooms, when I have a chance to talk, I am sitting down and I am hammering them on procedural violations. I'm hammering them on statutory violations. I'm showing them how they violated their oath as an attorney for ethical violations. Well, after being in there with her, she got out of this, and I ended up with Judge Roberts. Judge Roberts was the chief senior judge. So now I'm on my third judge. I've had 3 prosecutors up to this point. And we got in before Judge Roberts. Judge Roberts sit down, started talking to me, and because me having a hearing problem, they had to give me a hearing device throughout this whole conversation with what we're doing here. But the prosecutor come up and said, well, Mr. Class came into D.C. and he had firearms readily accessible, and I objected to that because it wasn't readily accessible. It was inside my Jeep and it was locked up. But I brought up to the judge, I said, I want to tell you what. I said, let's you and I have an understanding here. Let's talk about this. I said, first off, your underling, which was Judge Scully at the time, Judge Scully just ruled here back in July 2014 that firearms were legal and that he upheld the Tom Palmer case, which was part of the Heller case and the Parker case, because he was a defendant in this. He upheld that your gun laws were unconstitutional. I said, he just made this ruling. I said, not only that, I says, under Title 18, Section 930, your property had to be posted. Under Section 8, it sits there and says, if you don't post it, you can't get a conviction on me. And the judge looked at me and says, well, we're going to have that ruling overturned. I says, good. I said, then let's go with what Thomas Massey said here and put in for a bill before legislation that he's going to defund the District of Columbia. He's going to see that the District of Columbia gets defunded. And he said, he looked at me like, how did you know this? Well, all through this is through research. We said, we're going to set this up for another status hearing. Well, all the time that I have got close between Harvey and I with what he's been helping me on, we got close to some 70-odd documents that we've been throwing into this thing. And we've been hammering them anything from the fact that these people were not American citizens, and we explained prior to the Civil War, to the Reconstruction Act, on how the federal government walked into the South. It took them over at gunpoint, told the southern states, you will relinquish your state sovereignty or we will shoot you right here, right now. They had to relinquish their state sovereignty, take on the federal side of this thing. That 14th Amendment was the verification that the state came under the federal government, because the 14th Amendment only applies to them and their kind, because if you get into Section 2 and 3 of the 14th Amendment, it deals with the president, the vice president, the legislators, and the whole 9 yards on their side of this fence. There's nothing that deals with freeing the slaves at that time. There's nothing in there. It dealt with public offices. Well, then we went back and showed where the D.C. is a corporation. And when they created the corporation, they dissolved the government. In 1945, we went back in and we showed under the 1945 International Organization Immunities Act is that all these public offices were turned over to the UN. So we don't have any public officials. Everybody expatriated except for you and I. You and I are the only ones who have never expatriated. This is what we come back and we start hammering them in our paperwork on. But we started hammering, and the more I started hammering them, I've had right there at the end I had the public defender and the U.S. attorneys pulled me off to the side, and they told me, said, Rod, said, we got one problem here. You know too much. You're walking in here with too much knowledge. We know you are right. We cannot allow. This is where the problem's coming in. He says, you know too much. And if for us to sit down and allow you to win, you would overturn every single court case in this country. When I got into my February 9th hearing, which was my final hearing, well, I was forced into a plea agreement because they didn't allow me to win. They was going to give me 21 years if I didn't agree to the plea bargain. Why? We got a lot of noise out here, and no one ain't on my side. Well, what we did is when I went in for my final hearing on February 9th, Judge Roberts asked me, he said, do you have any objection to your plea agreement? I said, yeah. I said, first off, your prosecutor lied to me. Your public defender lied to me. Your laws have been overturned. You guys lost your federal funding. I said, and I was forced into a plea agreement because you guys violated constitutional protected rights and the Second Amendment. So he looked at me and says, okay. He says, now, what's going to be your final statement here? And I proceeded to explain. He says, well, you can go file for an appeal. He says, you can do it under informer paupers. He says, because you know there's no money. I said, that's exactly right. So he allowed me to file informer paupers. But everything that we've done up to this point, Angela, a lot of these guys out here, they're not wrong on what they're saying. They're just not carrying it far enough. I went in this thing with the intent of being a prosecutor. I went into this thing to hit the shit out of these people. I went in here to expose the fraud. I'm not interested on trying to trim bushes with these people. And that's where a lot of the stuff, if we could trim the bushes, this is ideal. And I don't have a problem with that. Now, you've got a lot of good people on here. Their knowledge is wonderful. They got the right concept if we're with a legitimate court system. I did not walk into this court to defend myself. And that is where people having a mistake and having a bad idea with what I did not walk in here to defend. I walked in here to prosecute. I walked in here to hammer these people. And that is something that they're not used to. They're not used to having someone come in and tear them apart. They want people to come in and try to dance around the system. I'm going to put this in the same perspective of what is going on here. They're not wanting to put the fire out. We need to keep the fire going. Because if the fire going, we can keep our bitch going. With what I did in D.C., and I don't know how much it played, but with what I hammered the D.C. on, their gun laws have now changed across the country. I didn't do this for one or two individuals. I did this for the entire country. In the way I went after this, it opened it up for the entire country because the gun laws are being changed. Judge Scully just ruled again here last week in a second decision that is constitutional. It has no standing. And this is where one of the big differences with what I teach compared to what Carl teaches and what teaches and what was going on with Tim Turner and his bunch. But these guys went to jail. I'm not sitting in jail. I didn't get no jail time. I got jail time for contempt because I didn't show up. But I never got jail time for the gun charge. Put me in jail. This is where the issue's coming in. This is what I have done. Like I said, there's a lot of people don't want to run down this path because it is complicated, but it is not as hard as what you think it is. Any questions, Angela, or have I lost you? Angela? Sound like NSA is sitting down playing with the internet. Angela, you got any? All right, go ahead and sign off and come back in. Angela is signing, going out and going to come back in because I don't know if the noise is on her side or where it's at for sure because I got my side muted for my listeners. But you've got a lot of wonderful people out here, and they got a lot of wonderful ideals, but they're just not gone far enough with what they're doing. It's like you can sit back and say, I have a BMW emblem. An emblem does not give you the car. And throughout the years, we've learned to put pieces together. I may not have all of the pieces, but we've got enough with what we have here to expose so much on their side. And we are working on a PAG school that's going to be coming up here in June 27th over in Arkansas from June 27th to...
Can you hear me now?
Yeah.
Oh, my God. I don't know what was going on. I didn't hear any noise. People in the chat said they were hearing noise big time, and I didn't know where it was coming from. I unplugged my headset 3 times, so I guess it's on the TalkShoe, and I don't know. I mean, not TalkShoe, Skype, because I just got out of Skype and then came back on. And is it okay now, or is there still noise?
No, we're good now. We just had a lot of static going across this thing.
I hate when that happens, and I don't know what causes it to happen. I really don't.
NSA.
Probably.
They don't like what we're teaching.
Mm-hmm.
They don't like the knowledge out here. But the thing of it is, Angela, I've had FBI come to the house. I've had U.S. Marshals come to the house. I've sat down with these guys, and we got a retired FBI agent that came down here in July last year to the campground. And all these people have come to me with the intent to prove me wrong. And when we start laying out the statutes at large, well, we went back into the 1935 Social Security Act under Title V, Section 501, 502, and we're sure where there's a $1 million price tag on us at birth each fiscal year. She crapped. When I started showing their public offices is under UN, and they're not part of the United States anymore. They crapped. And this is a significance, because I get into the historical side of this stuff. Because when people coming up and asking me, Rod, where does it say that a name is a corporation? Well, I will take them over to Delaware Administrative Code under Title 8, which is corporation. I'll bring them into Chapter 6, Section 617, says their last name is a corporation. It's come out of corporate law. We'll take them into Texas Administrative Code under Chapter 79, which is corporation, under 79.31. It all has to be capitalized, because that's the only way the system is recognizing a corporation, through capitalization. That's the same thing with the style manual. So what we bring in, Angela, is I bring in the historical side. I show people where this stuff is at. So when you're walking in, and you're telling the judge that all capital name, or that I am not a person. And when I did this with Kessler, she sent me down to a psychiatrist. And I had a psychological evaluation that day for about an hour and a half, 2 hours. I got in there, I talked to the psychologist. I started going through a bunch of questions, and I started explaining stuff to her. And the first thing she started doing was saying, whoa, you're talking over my head. You're talking over my head. I said, excuse me, what do you mean I'm talking over your head? I've got a 12th grade education. You've got a college degree. I am being told there is no excuse for not knowing the law. And you're telling me that you don't know the first thing that I'm talking about? And you're here to evaluate me when you don't have a clue what we're talking? She gave me a flying bill of health and sent me right back up to the court. Set it up. He passed. There's nothing wrong with him. He's more than capable of defending himself. This is what we're coming in. I've talked to too many guys that's walking in here and saying, well, I'm incompetent. I don't know. I'm stupid. The moment you do that, you hang yourself as far as I'm concerned. But I can walk in here and I can put a psychiatrist to shame, and I can sit here and walk her through this stuff, and I can sit there and show them exactly what I'm sitting here talking about, and they're telling me that I'm talking over their head. That is something that is a pat on the back of what we're saying. They're not sitting down saying that what they don't understand. They're telling me I'm talking over their head. So they're acknowledging the knowledge. They are acknowledging what we're sitting here saying. This is what the judges, they're acknowledging, but they've never had anybody that just walked in and hammered them, because it's like what I dealt with up here in Raleigh. When that judge sat here and said, well, Mr. Class, they are private contractors. When I started to hammer him, he switched jurisdictions on me. He switched topics. He said, they are local government. I had to move with him for the local government. And when he went to the next topic, I had to move with him. I had to sit here and show him. I knew what he was talking about. I showed him where it was at and how he was wrong. And that's part of the problem that we're having out here. You can walk in and you can make a simple statement, but if that judge takes you to the next level and you can't explain it, you're sunk. I had a couple back in 2008 when I first did the Corn Novus paperwork. It was a husband and wife team. They lost their kids to the state. The court separated them, so they wasn't together. They both had to hire an attorney, and they got rid of their attorney. They came to me. We filed paperwork in. The judge threw out the husband's paperwork on a Friday. Monday, the wife went in, same paperwork, and he looked at her and says, okay, I want you to explain the paperwork. She said, what? She says, I want you to explain the paperwork. She says, okay. So she proceeded to explain about his oath of office being under Title 22 CFR Foreign Relations 92.12 to 92.30 on how the oath of office had to be done. She took him over to Title 8 United States Code 1481 under alien residence. He showed him the moment he turned around and took his oath, he relinquished voluntarily, he relinquished his national citizenship and became a foreign agent. And that's where he stopped the court case at that time. Because she was able to walk with him as he went through the different jurisdictions. She was able to walk with him. When they got their paperwork from Child Services, they sent the paperwork to me. I showed them how to read their paperwork. They went into court and judge said, oh, we made a mistake. This is the wrong jurisdiction. So they came back in another sheet of paper. I walked them back through. This judge did this 7 different times of acknowledging they had the wrong jurisdiction. After the 7th time, they got their kids back. This is the difference in what I'm teaching on what and how I do things. A lot of people feel that you don't have to know the rules and regulations. My attitude is you have to know their job. If you don't know what their job is, how can you tell them where their errors are at? And if anybody has ever watched and spent the time watching C-SPAN, or you watch the government legislation channel. I caught it here the other night. They were talking about Medicare. They're talking about the legislation. Not one single topic was ever talked about John Q. Public. When they were talking about that Medicare legislation, it went back to the agency of the government on how they were to operate, how they were supposed to be helping, and how it was supposed to benefit the American people, not rip them off. And this is what I'm sitting here saying. This is what I did when I went up before Kessler. Because when we got into 902 under the rules of evidence, and we started to explain the prima facie side, I walked in and showed her in 1925, the statutes at large stopped on March 4th, 1925. Volume 44 picked back up on December 16th, 1925. So between Volume 43 and Volume 44, there's roughly like 9 months that were missing. Supposedly, HB 10,000 was a legislative bill on December 7th, 1925, codify the statutes at large to make the United States Code. I walked in with the statutes at large, and I sit down and says, number one, we have a problem. You can't charge me under USC codes. Why? Because under prima facie law, and here's your statutes at large, that shows that your law stopped on March 4th, 1925. Supposedly, HB 10,000 was passed on December 7th, but here is Volume 44 that shows that it picked up on December 16th, which was 9 days after, supposedly, it was passed. It shows that it was never passed. It shows that in 1935, and here is the Federal Register, where Congress allowed the President and created the Administrative Committee allowed them in 1935 to codify the statutes at large for administrative use only. And here it is under the Industrial Recovery Act of 1935 that shows that the USC codes are purely administrative and it only applies to you and your kind and not to me and mine. And she looked over at the prosecutor and says, "Can you rebut him?" He shook his head, no, he could not. I said, "Here's the proof. Your laws don't apply. This isn't me telling you your USC codes don't apply to me. Here it is in legislative acts that shows that your USC codes don't apply to me. Here is the definition of the word person. That word person is under Title V, USC Code, under 552A, and it says a person is an individual, and it defines an individual as a U.S. citizen or an alien applying for permanent residence. That U.S. citizen don't apply to you and I. That's that 14th Amendment citizen. We're American nationals because whenever they relinquished their citizenship under Title VIII, 1481, they walked out of their American side of this thing. They walked into the foreign side. And this is what we're coming back in. This is how we're hammering them. They could not rebut. They could not disprove their own congressional records. This is why, with what I'm teaching, it's difficult. But if we will start taking the time on individual cases, we can start hammering these people. There isn't an area that I can't get into, whether it is IRS, whether it is child services, whether it is criminal, whether it is traffic. There isn't an arena that I can't walk into and bring up their own statutes, which is most people they can't. And it's understandable. But I've had a lot of time here on my hands to go back and research this. But a lot of stuff that like Carl Letts has come up with and Thornton has come up with, they have given me a lot of information for me to come back in and look at. And I try to improve and add to and show where its stuff is at. There's nothing wrong with their material. They got some of the best material out here. It's just that I sit down and I'm able to walk into any jurisdiction with a judge, and I can walk in. And this is what actually flabbergasted the U.S. Marshals. And this is what flabbergasted the FBI when they watched me work, is that there wasn't an area that I could not walk that judge through and hammer that judge and show where they were wrong. I've watched too many people walk into a courtroom that is got set up on one little thing. As long as that judge stays there, they're fine. The moment that judge sits there and says, well, you know what, I really don't give a rat's rip, and we're going to go do this to you, and you freeze. You don't have anything to sit here and say, you've lost. And this is where I have been able to hammer them. I have more information than they've got questions, because every time they ask, I give them an answer and I tell them where it's at. And after a period of time, they don't play no more, because like I said, every time I turned around, they kept postponing my hearing. I started out on May 30th, 2013. This thing got dragged out to February 9th, 2015. I dragged them out this far on hammering them, and now I'm in the appeal side of this thing. But I hammered the prosecutor on some of the issues that within 14 days after I filed paperwork, he had to address my paperwork. But what was going on, all my paperwork, when I sent it in, it went to the mailroom. It went straight into the judge's chamber. Why? Because he made it in camera. He made it private. And when it went into his chamber, it was sent there for about 2 weeks, week and a half, 2 weeks. Then it got sent down to the clerk of court in another week, week and a half, 2 weeks. They finally logged it in, but when they logged it in, they sealed it for public viewing. It was not for public viewing. They sealed my case and all my documentation, except for just a few of like my inter appearance.